Welcome, everyone. We'll get started. My name is Roger Fairfax, and I have the honor and privilege of serving as Dean of the Howard University School of Law. I want to welcome those here in the beautiful Pauley Murray conference room, and also many folks online. Thank you for joining us. And I am here to welcome to the podium our alum, Mr. Charlie Bingham, who is the founder of the HBCU IP and Tech Law Summit, and a proud member of the class of 2008. And so without further ado, I welcome Mr. Bingham to the podium. Thank you.
Good morning, greetings for those who are online. We appreciate you joining us and your patience with our technical difficulties. With that said, usually this is our 8th year. Usually I kind of get up here and just go off the top, but I've been told by my wife, keep it focused. So I am going to presidentially read to you all. Thank you. First off, for our people online, for your patience, the technical difficulties, I think we have them figured out by now. I'm looking at our camera guy. You all should be able to see. But if you can't hear or see, or you're having issues and you're online, please put it in the chat, and we have someone who's going to work with you to try to adjust it. So today is not just another conference. It is a convening of architects of the future. Every major technological shift in history has been shaped by the voices present in the room. And today, you are in that room. Whether you're joining us here in person or tuning in virtually, you are part of a movement that is influencing how innovation is built, governed, and deployed across society. We gather at a pivotal moment. Artificial intelligence, or AI, is transforming industries in real time. Cybersecurity threats evolve daily. Data is currency. Intellectual property is power. And the legal frameworks that will determine whether these technologies empower communities or deepen inequities are being written right now. The purpose of this summit has always been clear: to educate, equip, and elevate diverse legal professionals in the IP and tech industry so that innovation is fair, transparent, accountable, and inclusive. We are not here simply to observe change. We are here to shape it. Since our inception, the participants and speakers in the summit have been on the front lines of AI development, governance, and accountability. They have been the voices in the critical rooms, asking hard questions, challenging assumptions, and ensuring that emerging technologies serve everyone. Today, you will hear from leading technology lawyers, policymakers, and entrepreneurs who are wrestling with the most pressing issues of our time. And they won't shy away from lively, thought-provoking debate. For our law students in particular, let me offer you your first lesson in IP and tech law. You must get comfortable being uncomfortable. Innovation does not wait for certainty. The law is constantly evolving, and those working at the cutting edge rarely have perfect clarity. That uncertainty is not a weakness. It is your opportunity. It is where leadership is forged. As technology evolves, so too does our responsibility as lawyers. Throughout today's program, you will hear discussions that challenge you to think bigger, deeper, and more strategically about your role in shaping the digital future. None of this would be possible without our incredible sponsors. Please join me in recognizing and thanking Dean Fairfax from the Howard University School of Law. We have Perkins Coie, Wilmer Hale, Greenberg Charick, Reed Smith, FBT Gibbons, Davis Wright and Tremaine, and an individual person who felt so passionately about this that he decided to donate in his individual capacity, Marty Donovan. I want to make sure I give him a special shout out. And I know I'm not supposed to go off script, but it's me. I want to say something special about our donors because these are tough times, and you will hear a little bit more about it later in the day. When you're trying to raise funds for minorities or anything that could be seen as DEI, it's very difficult in this current climate. But I want to shout out, I'm so proud of Perkins Coie and Wilmer Hale. They are two of the firms that push back, use their resources to fight executive orders. And I think as of yesterday, the Department of Justice decided, they did a reverse and decided we're going to leave them alone. We don't want that fight. I just want to say to our students, that's the type of firm you want to make sure you give a second, a third, or fourth look, because they show you who they are. Character comes out in tough times. You get a chance to see who. So I'm giving them a special shout out because when I seen them on the list, I'm like, those are firms that have been down with us from the beginning. All right. I wasn't supposed to do that, but we also want to extend a special thanks to Shawana Skinner, the executive director of IPSA, Latif Mtima, Roy L. Austin Jr., the leader of the Hustle AI initiative. He's going to say some brief words after me. But Howard now has an AI initiative. Mr. Austin Jr. is leading that effort, and we have decided to partner together. It was a great collaboration. It only made sense when we started talking about his objectives and our objectives for the student. We all want you guys to win. So after hearing from Mr. Austin Jr., we're going to begin with our first panel, Litigation, Governance, and the Future of AI Accountability. Students and those online, I want you to lean in, ask questions, network intentionally, and be present, because the future of technology law is not something that will simply happen to you. It's something you have the power to help design. Welcome to the summit.
So thank you very much. And Charlie forgot to tell you the second rule of IP law, and that is always do what your spouse tells you to do. Look, I just want to say a very, very brief thank you, and that is thank you for being here. Thank you for showing up. Thank you for those of you who are online. But really a thank you to Dean Fairfax for having the vision to make Howard University School of Law the first school of law to have an artificial intelligence initiative. First one across the country, and the only one that is centered in civil and human rights. And that is incredibly important because that's where the tension is right now with the use of AI. I also want to thank Charlie just for bringing this IP gathering to Howard University, to having it here for 8 years, for bringing in the rest of the HBCU community. That's all I'm going to say because you're going to hear more from me in about 2 seconds. So with that, I'll have the panelists step up and we're going to jump into this. So thank you all.
My name is Malenka Clark, and I'm a senior advisor with the Howard Law AI Initiative, which you've just heard a bit about. It's my great pleasure to moderate this morning's panel, which, as you heard, Litigation, Governance, and the Future of AI Technology. I want to state the obvious. I'm going to just start by saying something obvious, which is that the development and deployment of artificial intelligence has had an impact on every aspect of our society, domestic, global, etc. Whether you think that impact is good or bad, I think we would all agree that the impact is profound. And so it's very much against this context that we're having this conversation today, where we want to talk about what the guardrails are, or are not, around the deployment of this technology, the legal, regulatory, and accountability frameworks that are shaping artificial intelligence. As we sit here at Howard Law School in the Pauli Murray room, no less, we of course want to talk about the civil rights implications. And so we're going to be able to hear what advocates are doing to really address the potential disparate negative impacts on our communities in particular. Of course, this is the negative or the dark side of this technology. But we're not here to be depressed. We do want to inspire you, the next generation of future lawyers, to really think about what your place is in this context, what the future is going to look like with you as leaders, as ethical architects, as advocates and builders of justice-focused AI. So with that, let me tell you briefly who we have to have this robust conversation. Kirk Nehra, who's a partner at WilmerHale and the co-chair of the Artificial Intelligence practice, as well as the Cybersecurity and Privacy practice. We have Damon Hewitt, who's the president and executive director of Lawyers Committee for Civil Rights Under Law. We've got April Dawson, who's the associate dean of technology and innovation, professor of law at the North Carolina Central University School of Law. And of course, we have Roy Austin, who you've just heard from, who's the director of the Howard Law AI Initiative. I realize I've sat you guys in the wrong order, so I'm sorry about that. But I've asked our panelists to each come up and do an affirmative presentation on their areas of expertise. I won't jump in between, just in the interest of time, so we can move forward. And then at the end of that time, we'll have the opportunity to have a Q&A with our panelists. So please, if you have questions, prepare them, note them so you don't forget them. And with that, I will turn it over to Kirk. Thank you.
Thank you very much. I very much appreciate the opportunity to be here today. My job for this session is to set out a baseline understanding of where we are on the law of artificial intelligence. We are at sort of a prototype example of law being behind technology. That is not surprising. We don't see very many technological developments that are as impactful and as comprehensive as AI. So we're seeing a similar kind of set of issues. But I do want to make sure people have a baseline sense of where we are with the development of law at this point. So if we could advance to that. There we go. One more. All right. So the law at this point is developing very quickly and somewhat chaotically. I often put sort of the idea of law in quotes because we're dealing with actual statutes, we're dealing with regulations, we're dealing with enforcement policy, we're dealing with things like contracts as becoming a baseline standard of behavior. Technology is clearly moving faster than the law at this point. I do think that we're seeing lots of complexity. You know, I'm a lawyer at a law firm, so I'm advising clients in terms of how to deal with these issues. We are seeing real challenges because of the uncertainty in how this area is going to be regulated. That is not only a question of the law being new, but also a question, as obviously people are aware, of a fundamental change in approach from the current administration compared to the last administration. And so that balance of risk versus opportunity is evolving in real time, and we have to pay attention to that very carefully. One of the things that I think will be useful to think about as people consider the evolution of this law is to think about how a very similar body of law has developed over the last 20 years, which is the law of privacy and data security. We're going to see similar regulators. We're seeing, for lots of both companies and law firms, similar people. You know, that's my background is privacy and security. I'm evolving into doing AI work. It's a very similar kind of thinking. We're dealing with the Federal Trade Commission. We're dealing with the state attorneys general. We're dealing with the same kinds of regulators. And I expect we will also see the law develop in a very similar way at this point. We are also likely, particularly in the short term, to see very significant differences between federal level law and enforcement and state level law and enforcement, particularly over the next few years. At the same time, one of the points that I've been trying to stress with my clients is that these choices that people are making today on their utilization of AI will have a long tail. And so decisions you're making today are not just subject to challenge by this administration this year, but also will be subject to challenge 3, 5, 10 years in the future. And so that's going to be a critical part of thinking about these issues going forward. Why don't we go to the next slide, please? So just to give you a sense of how we're evolving, the last Federal Trade Commission, meaning in the last administration, had a very aggressive view about the need to regulate artificial intelligence. They believed that they had the authority to do it under their existing body of law, mainly Section 5 of the Federal Trade Commission Act. That is a wonderful law that has evolved in 1,000 different ways since it was first passed in roughly 1913, when we were certainly not thinking about artificial intelligence or privacy or data security or anything like that. Their idea was that although AI tools are novel, they're not exempt from the existing rules, and the FTC will vigorously enforce those rules. They were also looking at an idea of what they called unfairness, which is one of the components of the FTC Act, and they were trying to expand their enforcement authority to cover AI activities that they believed were unfair. At the same time, they were very aggressive about the risks of AI. I might argue they were almost too aggressive. For example, I work in a lot of the healthcare area. In the healthcare area, the chair of the Federal Trade Commission made a couple of speeches where she basically said that use of certain kinds of data should be off limits for training AI, including healthcare data. That was an interesting position as I thought about it. That essentially says that you can't use patient data in the healthcare system to build AI, which means we wouldn't have AI in the healthcare system. And so it was a little hard to see who that was actually going to be good for, or why AI was so different than other kinds of analytical tools to justify a fundamentally different approach to that. So we had this idea, they recognized the concerns, they were perhaps leaning towards the risk part more than the opportunity part. Let's go to the next slide. We now have a fundamentally different approach at the federal level, where they have basically said we want to be full steam ahead on development of AI technology. They haven't actually said we don't care about the risks, but to some extent the idea is they don't care about the risks. They want to build the technology. They're concerned about competitive issues with other countries. We are seeing a question about state versus federal regulation in the privacy space that, again, is a good analogy. We have lots of state laws, and there's a question about whether there will ever be a federal privacy law, and if so, whether that federal privacy law will preempt the enormous body of state law that exists. Right now at the federal level, they are trying to take the position that not only will federal law preempt state law, but we want to preempt that state law before there is any federal law. So they want essentially to prevent states from passing AI laws. We're going to watch that issue play out. I don't expect that will prevent states from passing AI laws, but that's clearly something that is going to be important to watch going forward. There's very little expected activity at the federal level on enforcement beyond things like fundamental misrepresentations. We're going to watch particular impacts. We may see things like impacts on children, which is something that at least the FTC continues to pay a lot of attention to. Let's go to the next slide, please. State level is very different. I don't think we yet have a model at the state level, but we are seeing more and more bits and pieces laws that are covering some smaller topics, some laws, particularly a law in Colorado, that are more comprehensive. The states are very concerned about use of AI, in particular with what we call consequential decisions. Important decisions, if they're used in a way that will have a potentially meaningful impact on consumers, they are very concerned about those issues. We're seeing more law requiring disclosure of utilization of AI. That's an interesting question even of itself. I mean, if you go to the doctor today and there's an X-ray, your X-ray will be read by someone else, perhaps in another country. You're not told that. You don't have a right to consent to that. You're not really asked about that. There's an interesting question as to if instead of that doctor in another country reading your X-ray, AI is going to read your X-ray. Do you have a right to know about that and give your permission to that? It's an interesting question. If the doctor is 98% accurate and the AI is 99% accurate, maybe the AI is actually better, but it's still not perfect. And so we're going to watch the development of law in that area. So we are seeing at the baseline state level, we're seeing some new laws that are specific to AI, where there's a new law that has an artificial intelligence focus. We are also seeing in the growing body of state privacy laws, AI components being included in the state comprehensive privacy laws that exist now in 19 states. We'll probably see another 3, 4, 5 this year many of those will have more of an AI focus. Let's go to the next one, please. So again, what does this mean overall? The law is changing very quickly, and I think one of the big picture messages we are sending to our clients is that the regulators, again, used to be the FTC, perhaps not this administration, but certainly the state attorneys general, are not waiting for there to be AI law to think about their cases. They're thinking about general consumer protection laws that already exist and how they can apply those kinds of laws to AI practices as they are developing. So companies need to be paying a lot of attention to that. That means there is very little certainty, and so we're trying to give advice, again, relying on that history of how privacy law has developed to use that as a baseline for thinking about what kinds of issues the regulators are likely to be concerned about. It will not surprise me if we see U.S. law develop almost exactly the same way as we've seen U.S. AI law develop almost exactly the same way as we've had privacy law. Compared to Europe, Europe has one major privacy law. Europe already has one major comprehensive AI law. In the United States, we've never had a comprehensive privacy law. We have lots of different laws, many of them at the state level. I expect that pattern is going to replicate itself in connection with AI, at least over the next several years, until we get to a point where Congress, if it ever gets there, will be thinking about a comprehensive privacy law. I do think that there are certain practices that will drive higher scrutiny. Again, sensitive conditions, use of sensitive information, high-risk decision-making involving consumers, AI being applied to audiences like children is another example. We're going to see more and more litigation, particularly class action litigation, which I think might get ahead of the actual statutes. And I do think we're going to see some regulatory investigations, particularly at the state level, but we are likely to see a lot of investigations that are driven more by trying to understand what is happening in the field than necessarily trying to bring an actual enforcement case against an actual entity. So again, that's the baseline that we are seeing at this point. We are, again, there are certainly, you will hear certain commentators say there isn't yet AI law. I don't think that's an accurate statement. Is there comprehensive AI law? Absolutely not. So we're going to see lots of sort of bits and pieces of individual things, and the challenge for lawyers advising their clients is that you're going to have to figure out how all of these different pieces fit together. Again, very much like what we're seeing with privacy law, where companies may be hit by 1, 2, 5, 10, 15 different privacy laws, most of which don't say exactly the same thing and may have even inconsistent issues. We're likely to see some inconsistencies. We're certainly likely to see one law talking about these 6 things, another law talking about 8 or 10 things, 4 of which are the same, but a bunch of them are different. So that's going to be the real challenge that we are seeing going forward. I think that might be the last one. So lots of law, for those of you who are law students, the law will be different when you graduate than it is today. Even if you're a third-year student, I mean, by the time you start working next fall, the law will be different. It's going to be happening very quickly, so it's going to be really important to stay on top of that. But again, lots of moving parts, really interesting issues at this point.
My name is Damon Hewitt. I'm president and executive director of the Lawyers Committee for Civil Rights Under Law. I want to thank my friends, colleagues, and my board members, Roy Austin and Malika Clark, for having me, and also Dean Fairfax, who's also on our board. Some of you may be on our board soon as well at the Lawyers Committee. Our organization was founded in 1963 at the behest of President Kennedy at a critical time for civil rights. It was just days after Medgar Evers was assassinated in the driveway of his own home, and he asked the question, where are the lawyers? And so a racially integrated group of lawyers, white lawyers and black lawyers, came to D.C. and met in that pivotal meeting. And that meeting begot the Lawyers Committee for Civil Rights Under Law. We are a peaceful army of private attorneys general who vindicate civil rights. And we work closely with our staff of almost 80 people with the private bar on pro bono matters. We have leveraged in the last decade over 1 million pro bono hours, working closely with law firms, and not even executive orders are going to stop that from happening. So we're very proud of that tradition. It's a pleasure to be here with you today. I want to give you maybe a disclaimer, or you could call it a clarification, just to set the level here. I and the Lawyers Committee are not anti-technology. We are not anti-AI. What we are is we're pro-black. What we are is we're pro-democracy, we're pro-opportunity, and we are pro-civil rights. So please take all of my remarks and all of our work in that context, in that vein. We do believe that technology has the power to transform society in profound ways, and I remain optimistic that transformation can improve our lives and our daily lived experience. But we also know that AI harms have occurred, or harms have occurred because of the way that AI is used. AI is not the enemy, it's the deployment and the lack of any checks and balances at the federal level, at least, that concerns us the most. We believe that innovation must center people, it must understand context, and we live in a racist society. We live in a society that has a lot of issues, a lot of problems, and also a lot of promise. And so we just need the technology and the development thereof to take that into account. So I want to ground this discussion in our view, and I like to even call it a fact, that AI is not value neutral. It's not just a hammer sitting on a shelf. It is a tool, but it's not just value neutral. These systems, the AI systems, reflect not only the values and judgments of the people who design them, but of course the people who use them and the data and systems upon which they are built. So you've heard the phrase probably oftentimes garbage in, garbage out. It's almost outcome determinative what kind of results a tool will use based upon how the tool is designed. So in that way, we believe it's not value neutral. A couple quick examples of this. Researcher at MIT found that facial recognition systems produced error rates approaching 35% for darker skinned women compared with less than 1% for lighter skinned men. So that's not just a black, white, brown, white thing. That's also shades and gradations in terms of like people's phenotype, in terms of skin tone. Amazon developed an AI internal recruiting tool that learned how to penalize women's resumes based on containing the word women's in plural. That necessarily wasn't the intent, but that's exactly what the tool did. And of course, there's social media algorithms that are optimized for engagement and entertainment, but not accuracy or social consequence. Those are not value neutral contexts. So these things suggest that there's a concerning reality that must be addressed in order to mitigate and protect our civil rights. AI systems are trained on human data, as I've mentioned. They reflect human choices and biases. They're deployed within institutions in which inequities already exist. So we believe there's ways in which, at least unintentionally, that discrimination is being hardwired into AI tools. What can we do about that? What should we do about that? At the Lawyers Committee, we believe that traditional civil rights tools remain essential for addressing discrimination at scale, including with respect to AI. But we also recognize that the technology sector is aggressively resisting oversight, and frankly, there's a bit of gray area. As much as I like to, think that all the existing civil rights laws can fit the bill, and we won't concede that they don't apply, but there is a bit of gray area. AI complicates civil rights enforcement because most algorithmic harms do not arise from explicit intent, as I alluded to earlier. Traditional discrimination can be systemic or individual, of course. It can be racist intent, or it can be disparate racial impacts. It can operate through policies, practices, and individual decisions that may seem facially neutral but have devastating consequences. Of course, when AI is trained on biased and incomplete data, that discrimination becomes embedded, once again, in the system itself. Our civil rights laws, especially the Civil Rights Act of 1964, were built around human decision makers. The law assumes essentially that we can identify the employer, the landlord, the supervisor, the person responsible for a discriminatory decision or policy. But when you're talking about an algorithm that disproportionately screens out applicants by race or disability, the responsibility may become less clear. They're in your gray area. Industry experts will reiterate that discrimination is already illegal, and therefore we don't need additional regulation or laws for the tech sector. But the question remains, who is responsible, and where's the transparency when harms do happen? Is it the software developer? Is it the company using the system? Is it the data provider? Is it the person who pushes the button for the algorithm to do its work? Is it someone else? So these are gray areas rather that our legal framework was not necessarily designed to address. These gaps are not theoretical, they are real, and they're already shaping real world outcomes. I'll give you, to use the industry term, 2 use cases although it's almost the opposite of use cases. One is shopping while black. And this has to do with a well-known incident regarding Rite Aid. In 2023, the Federal Trade Commission, what do you call it, the old FTC, the prior FTC, filed an enforcement action against Rite Aid for use of facial recognition technology. Rite Aid, like many retail stores, has been concerned with shoplifting. It seems like there's been this proliferation of new security measures all across. Hard to tell sometimes whether that's real or fugazi, what it's really based on, but you see it in lots of different places, retail shops all around the country, including drugstores. And so it turns out that what Rite Aid was doing is they were trying to identify shoplifters, but not enforcing shoplifters aggressively and making sure they were charged and prosecuted, but identifying people as shoplifters as they walked through the door. Of course, this is what happened. There were lots and lots of false positives, especially high rates for Black, Latino, Asian customers, and particularly women in those demographics identified as shoplifters. So just think, a mother is going to pick up some medicine for her sick child or a personal care product, and is hustling, to make this happen, and then she ends up being questioned, stopped, because the algorithm decided that she is or is likely a shoplifter. Doesn't seem particularly fair. That's not a tech malfunction, that's a civil rights problem. Another case, playing while black. There is a fairly well-reported incident that happened in Baltimore County. A young boy named Taki was, I think, just finished football practice, and he was enjoying, a bag of chips. And he's just kind of standing out there. Next thing you know, he and his friends are swarmed by police with weapons drawn. It turns out the school district, has an AI tool designed to identify weapons, ostensibly to keep young people on campuses safe. Well, that tool mistook a bag of Doritos as a weapon. So think about the negative consequences that could have ensued. This could have been another Tamir Rice. He should not have suffered the fate that he did, but even in that instance, he was using a toy gun. This was not even that. It's a bag of Doritos. So think about the harm that could have happened. And as a parent, those of us who are parents or who have been children, as we all have been, have either given or heard the talk from our parents about how to deal with law enforcement, what to do. And Bataki reported that all he could do is thinking like, am I going to die? That's the thought that was in his mind in this incident. And it could have happened to any of us or any of our children. So these incidents illustrate that civil rights concerns come at us real fast, and there's ways in which technology can accelerate things that make life better. It could also accelerate, multiply, magnify things that make life much worse and potentially ending it. So these systems have a relative dearth of accountability and transparency. School officials, police officers, and the tech vendors would each argue that they're just simply following procedures and best practices as they have defined them. But from the perspective of the people on the business end of these harms, responsibility is important, but it's even beside the point. It's about the harm that's occurred. Again, these systems are being deployed in environments, in contexts in which discrimination already exists. Black students disproportionately get funneled into the school to prison pipeline. I've been profiled while shopping more times than I care. Half the time, they think I may steal something. Half the time, they think I work there. So, it's like you can't really win for losing out here in these retail shops. So examples like this show how students, families, all of us have really no meaningful way to challenge these harms, certainly before the fact. In theory, the AI tools are designed to promote safety, but they can have these consequences. So what do we do? A prior speaker mentioned that there is pretty much no regulation, so nothing comprehensive at the federal level, and that is exactly true. And we believe that at the Lawyers Committee that ultimately federal legislation will be needed. Quick aside, we are using state laws as well. There's been a smattering of litigation. We are litigating a case right now using DC's human rights law and its consumer protection law through a racial justice lens to challenge Meta for algorithmic bias in advertising. So there are ways to do that, but we're looking at the federal level as well. So we think federal legislation is ultimately needed to address what I call the gray areas. That's why the Lawyers Committee has been proud to help play a lead role in designing and supporting a bill known as the AI Civil Rights Act. This is a bill designed to modernize civil rights laws for the information age and to address algorithmic bias and other potential harms of AI. This bill has been introduced simultaneously in the House and Senate this Congress. We understand what the politics are and where bills may or may not go, but this introduction is important. Quickly, I'll say the bill has an affirmative non-discrimination provision that makes clear that AI systems are subject to non-discrimination mandates. Second, it has an audit requirement. It requires impact assessments and bias testing both before, during, and after deployment of high-risk AI systems. Third, there's transparency requirements so that individuals can know when automated systems are making consequential decisions about their lives. I think a prior speaker used that phrase, consequential. I think that is more than a phrase. I think it's going to, people are looking for bright lines or kind of limiting principles, and I think that's something to explore. And then fourth, the bill would clarify liability. There would be a private right of action to sue and vindicate one's rights, so that companies and others can avoid responsibility. So in short, the legislation would fill those gray areas. There are some people who suggest that the push for AI regulation, comprehensive regulation, will stifle innovation. We think that is patently false for a couple reasons. Number one, we think that a zero regulation environment is actually bad for business. We think companies there's a chilling effect on innovation when you don't know when that other shoe is going to drop. You don't know, could we be held liable by some court of law? So we actually need some rules of the road to promote innovation. I also think that lack of regulation is especially bad for startups because they can't withstand potential liability the way bigger companies can. The second thing is this. The civil rights laws of the 1960s did not stifle innovation. Requiring desegregation of buses and hotels didn't shut down public transportation in the hospitality industry or airline industry. It actually made things better for everyone, and that's what we're looking for here. So as I wrap, I'll just say that civil rights enforcement has always confronted systems that claim to be neutral, but actually had devastating consequences for our people. Poll taxes were once described as neutral. Things of that sort. Redlining maps, standardized tests today, we're told they're neutral. But they're giving us warped notions of what merit is. In this place, this campus, Howard University School of Law, is a place that redefines merit in our own image every day. So I know that this institution gets it. AI presents a similar risk if we don't watch out, if we're not careful, and if we have zero comprehensive guardrails. Maybe that's the operative word, not just regulation, which is a dirty word for industry, but guardrails, which we think are better for everyone. Tech is already reshaping our society. Can we play a lead role in what that reshaping looks like? Thank you.
Good morning. Good morning. I'm April Dawson. I'm the Associate Dean of Technology and Innovation at North Carolina Central University School of Law. And I am a product of 3 HBCUs. I always like sharing that. I went to Bennett College in Greensboro, North Carolina. I received my undergraduate degree in computer science. I am a proud graduate of Hustle, graduate in 1994. Yes, so it's always a pleasure being home. And I say I'm a product of 3 HBCUs because I've been teaching at North Carolina Central University School of Law for 20 years. And so I've grown up as a law professor and as an academic supported by a really wonderful institution. So it's a pleasure being here. I love talking about technology. As I mentioned, my undergraduate degree is computer science, so I love the technology. I geek out all the time. I can talk about it all the time. And as excited as I am about the technology, I'm also incredibly fearful and concerned about it. And what I focus on when I teach my students and talk to my students about the technology is who's in the room when these decisions are being made. Are the people in the room folks who've been trained up in the tradition of Howard University School of Law, or North Carolina Central University School of Law, or any of our wonderful HBCUs? because the technology is coming, it will be used, and we've got to make sure that we're there when these hard decisions are being made. All right, so first, my comments are mostly targeting the students. So let me first get a show of hands of all of our students who are here. All right, wonderful. Raise your hands high. Okay, all right, great, excellent. And of the students who are here, how many of you are 3Ls? Raise your hands high. Okay, congratulations, 1 foot out the door. 2Ls? All right, okay, halfway through. You can see the light at the end of the tunnel. Any 1Ls? Okay, all right, they're studying hard, trying to make it back next year. We understand that. Okay, all right, I'm gonna have you advance to the next slide and the next one. Okay, so we've all heard that technology is going to take our jobs, right? And it will, without a doubt. It is compressing the job market, and there are certain jobs that are being done by humans that without a doubt will be done and are being done by technology. Right? The question is, will AI also create more jobs than it takes away? So potentially, but we're already seeing in the market a compression because of technology. And one of the things that we know is that technology is actually impacting a lot of white-collar jobs, knowledge work jobs. And that has an impact on graduates, college-level graduates. And what we're seeing is that the unemployment rate, I'm going to have you go to the next slide. So this slide on your left shows the unemployment rate for college graduates. And that blue line there in the middle, is recent college graduates. And you can see that the unemployment rate for recent college graduates is higher than all other graduates. And that's trending upwards. Now, it's probably trending upwards for a lot of reasons, but without a doubt, it's trending upwards because of AI and emerging technology. The slide on your right, the graphic on your right, shows the underemployment rate for recent college graduates. So that blue line, right, we're hovering above 40%. That red line there, that's for all college graduates. So what happens when the unemployment rate for college graduates increases? What happens to law school applications? Any of our law students want to guess? Who wants to be bold? I'm a law professor. I can't help but asking folks to participate. Of our law students, who wants to hazard a guess? When college graduates, when that unemployment rate increases, so it makes it difficult for college graduates to find work, what happens to law school applications?
Take a shot. Do they apply to law school or try to go to law school?
Absolutely. Thank you, sir. All right, next slide. Okay, so on your left, this is showing the law school applications. You see that trend, that spike upwards? That's 2025. That's this past fall. So the applications are skyrocketing, and that graphic on your right is showing the enrollment from fall 2025, this past enrollment. You can see a really big spike there, hovering around 2010, right? When we had our economic problems in 2008, right? And you had the law school applications increase. And that was a heyday for law schools. So in law schools, admissions directors were like, woohoo, we have our pick, right? We've got this amazing pool. And so law schools were increasing the numbers of law school students that they were enrolling. And we are trending upwards, again, because we see the impact that AI is having on our society as it relates to actually everyone, but also college graduates. So law graduates, that number is going to increase. But if AI is impacting the job market, especially for white-collar workers and knowledge workers, what does that mean for the legal profession and law school graduates who are seeking employment? Right? So next slide, please. All right, so Now, 2024 employment, right? So these were actually the folks that came into law school around the COVID time, 2021. 93%, almost 94% employment rate, which is great, right? Which is great. However, the summer of 2024, the offers for 2L students was at an all-time low. Also, when we're thinking about, if you look at this box at the bottom, the median number of offers made this past summer, 2025, was at its lowest since 2020. And in the larger firms, it was at its lowest since 2012. So as we're thinking about how technology is changing how work is being done and how businesses are thinking about what their headcount should be, needs to be, how to right size the headcount, for law students, you all especially need to be thinking about what does the future hold and what does the future demand in terms of how lawyers are doing their work, what clients are expecting, what employers are expecting. Because the numbers are going up, the headcounts are going down, and it's going to require you all to think really, really strategically about your field and your work. All right, next slide. And so I want to jump into that. Okay, so one of the reasons why I wanted to see who our 3Ls are in here. So if you have employment, wonderful. If you don't have employment, it will come. But there are a couple of things that I want you to do in light of where we can see the momentum heading in terms of legal jobs being available. If you are not using these AI tools, you need to use them. You need to use them because it's going to dramatically impact how lawyers actually do their work. It's going to impact what employers look for when they're trying to decide in this group of amazing recent law school graduates which ones they are going to pick, because they're going to be more selective, because they have to be, right? You want to make sure you're the one that they select. You need the job. We want you to have the job, but also I want you in those rooms when employers, when clients, when Rite Aid is making a decision about whether to use this facial recognition software. Who was at the table when that decision was being made? Right? You all need to be at the table. But if you don't understand the technology, you can't engage in those discussions. It's as simple as that. And you may be brilliant, but we know that the job market is compressing. So what else do you need to have in your toolkit to make sure that you are the ones that are in the room? So the other thing for 3Ls, if you have a job already, hope you do. If you don't, again, it's going to be okay. You're going to get one. I want you to reach out to your employer and let them know that you're interested in what they are thinking about in terms of AI and technology. Because, Kirk, he mentioned what his firm is doing. His firm also has a group where they're talking about how AI is going to be used within the firm, not just advising clients, but how are we going to use it internally? And I can tell you that conversation is happening across the board, all law firms, all businesses, because every business is now an AI business. So you want to go ahead and start getting an understanding of what's going on, what discussions are taking place. You also want to identify those within those organizations who are the innovators, who are the forward thinkers, who are thinking about not just where the puck is, but where it's going. Those are the rooms that you want to be in, right? So Kirk is on the cutting edge of these discussions. I hope that, associates that will be starting in the fall, have already kind of reached out to you and your team about, right, what can I be doing now to think about how I can be of tremendous value to the organization. So reach out. If you don't yet have a job, I want you to do informational interviews with innovators and forward thinkers within the space that you want to practice. You all are puppies right now. Everyone loves puppies, right? So when you send an email to someone and say, I'm a law student, I'm so excited about the work that you do, can I take 30 minutes of your time and just pick your brain about, right? More often than not, the answer is going to be yes. Now, don't just reach out once, right? Because we're all very busy and sometimes things get lost. So be bold. Reach out at least twice, right? But again, you want to get into the minds of those who are currently in the profession who are forward thinking. All right, if you are a 2L, or we don't have any 1Ls here, but spread the knowledge with your colleagues, you all need to be taking law technology classes. Roy Austin, I know, is teaching an amazing class this semester. I know there have been other classes that have been offered here. Y'all need to take advantage of that, right? And if you can't take the class, you need to tap them on the shoulder and say, I wish I could be in your class. I can't take it because I've got this conflict. Can you share your syllabus, right? Or maybe you can visit the class when he's got a particular guest speaker. But you need to start immersing yourself into these issues and into these topics. All right. I want to emphasize something. So using the tools, right? And I encourage all my students have to use the tools in the classes that I teach because I want them to be really comfortable with them because you can't fully understand them if you don't use them. And I know there's this tension and we talk about it all the time. Why am I using these tools? And these are the same tools that are doing harm to my community, right? The environmental harms, the exacerbating discrimination that we see that Damon talked about, right? Should I be supporting these tools? And the reality is that these tools are being used within the legal profession. And if this is a profession that you choose to enter into, and hope you do because we need you there, you gotta understand the tools. Even if you're not an AI lawyer, without a doubt within your organization, you need to learn how to leverage them so that you can be more efficient. And when we think about social justice work, the great work that Damon's doing with his organization and his team, we can't be at a disadvantage, right? Those of us that are in civil rights organizations. And if the big boys are using these tools to be more efficient and effective, we cannot not use them. I remember when I was at Howard, I went to a law firm, had no experience with law firms or corporate America. I was talking to a classmate of mine, and we were talking about using secretaries. I wasn't using the secretary, right, or support staff, because I didn't understand really how. I'm working 60 hours a week, doing most of, stuff that I could have gotten assistance from someone else. And you've got other folks in the building, right, who did understand how to leverage support so that they could spend the majority of their time doing the heavy lifting. So I'm putting my table of contents together, right? That's not time well spent. So if we understand how to use the technology and leverage the technology, it'll make it easier for us to fight those necessary fights that we need. All right, the last slide real quickly. All right, so AI governance. So the other thing that I want you to think about is that the practice of law is evolving and changing, and the role that lawyers will be playing in society is expanding. And one of the reasons why I want you to tap into folks who are outside of, the academic bubble is that you've got folks on the ground. The reason why I want you to talk to those innovators and those creative thinkers who are not just doing the job that they've always done, but thinking about what's around the corner. Right? I have fewer years ahead of me in my professional career than I have behind me, right? If I do nothing else, I'm fine, right? Because things aren't changing in my professional life that much. Hopefully I'll have another good 15 years. But you all, students, you all are at the beginning of your careers. And so you need to be really strategic about what's coming and what you need to do today to make sure that you're ready. So AI governance is a field, right, that existed. We certainly had lawyers who were doing that work. But this is now an entire field, profession, that didn't exist by at least this name 5 years ago. Right? What else is coming? What other areas do we need bright, brilliant, socially justed-minded lawyers in? What other fields? How are things expanding? So as you're thinking about technology, we want you to make sure that you think about not just where we are right now, but where we are moving, and we're moving at an accelerated speed. So we have seen, like even within this last 6 months, the way the technology has changed has been just mind-blowing. So I'm going to go ahead and end it there. I wish the students and everyone great work, and that's for me. Oh, okay, sir. All right. Well, I will take questions, but I don't want to, yeah.
You like engagement. I know Roy is about to get up there. I just want to say to the students, what she's saying is absolutely correct. As an innovator in-house, another area of employment is going to be able to, can you explain how the company is using AI? You need to, and a lot of times product and engineering, they don't necessarily know that. They just know AI is in there. Lawyers are going to be needed to translate from the product and engineering people how we use AI, because every one of your customers is going to want to know how you use AI. So that's another critical area. And that slide she put up, I hope all of the students took a picture, because that was very important. The 3L, the 2L, you need to be using it. Just wanted to.
Thank you, sir. All right. Thank you.
So good morning, everyone. So I'm hopefully going to be quick, but you never know when I get behind a podium. So I'm just saying hope. Keep hope alive here. We need to be reading the newspaper right now when we're having this discussion. Because what is happening, if you aren't following the Claude OpenAI Department of Defense battle right now, you're missing out on something that is incredibly important. Very briefly, what Claude is saying is that there are only two really small things that we are asking the federal government to do. Not use our technology to surveil US citizens in the United States, and not use our technology for autonomous weapons. The federal government is saying, you can't stop us. You shouldn't stop us. We should be able to use it however we want to use it. So we're talking about the lack of regulation and the lack of comprehensive regulation. We're talking about the impact it's going to have on you. And as we sit here at an HBCU, we have to be talking about the impact it's going to have on not only black students and black people, but anyone who cares about civil rights and civil liberties. And why do we know that? Again, read the headlines. What is happening across the United States? What is happening in Minnesota right now? They are using the technology to surveil US citizens. ICE is using the technology, the facial recognition technology, to go to people's homes, people who were protesting, to sit outside their homes, to violate their First Amendment rights. And if this can happen in Minnesota, which isn't the most diverse place, imagine what's happening everywhere else. So the question becomes, if we don't have federal regulation, comprehensive federal regulation, as Kirk says, and I agree with Damon, I don't hate technology, I actually love technology, but it's going to hurt us if we don't do something about it. If we don't listen to what Professor Dawson talks about, and that is the fact it's going to take our jobs, what can we do to prevent those harms? So I think I have one slide. Let me go to that one slide. What does that mean at this moment? It means if we sit there waiting, and look, I'm not telling you to go to Claude because it's taking this stance. Let me tell you, Claude is the one who helped support what happened in Venezuela with Maduro. Claude is being what DHS is using right now to surveil people in the United States. But I'm telling you that if we sit around waiting for the federal government, this federal government, to protect us, as my mom would say, you're a damn fool. They ain't going to do it. So we have to build our own. We have to support our own. Support our own. I'm going to tell you right now. There's an app called Latimer AI. If you are not using Latimer AI, right, it's the same chatbot that the rest of you are using, but it's owned by a gentleman by the name of John, or created by a gentleman by the name of John Passmore. He is building an inclusive AI. If you are putting your money and your time, because time is what they really want from you right now, behind something that is going to do harm for you, then my mom is right. You a damn fool. I came to Howard University to build the Howard Law AI initiative because I believe we can build our own. We have basically 4 pillars of work. 1, building our own, in part using the Moreland Spring Arms Research Center and the fact that it owns the largest collection of black newspapers and the largest collection of black family papers, and most of that is non-digitized, and that is data, and data is currency in the AI world. We're working on something called the Impact Foundry, being led by a woman named Sandhya Rao, and that is the idea of creating an accelerator out of Howard Law School for all HBCU students, all HSIs, everyone who wants to build in civil and or human rights to lift up those products. We also have what we call the Justice Lab, and the Justice Lab is the idea that civil rights and civil liberties organizations are behind the ball, not you, Damon, you guys are ahead of the ball, but everybody else behind the ball on the use of AI. So how can we use it to help make the world a better place and a more fair place and a more just place? And that is being run by Malika Sadasar on this team. And then we have Next Gen Leaders, and that is run by the incomparable Malenka Clark. You're our moderator for this. And this is about making sure that we are in the room building, leading, and leading things and moving them in a just way. So with that, I ask Malenka Clark to rejoin us for a Q&A session.
Thank you, panelists. You are all preaching up here. It's really lots of insights to share. So we have a little bit of time for Q&A. I did see, I'm sorry that I had to cut you off, but I don't want to do that now. So if anyone has questions, raise your hands. I'll come to you. Sure, I saw you first. Go ahead. Yeah, sorry.
Thank you all for coming. I'm Kenneth Butler. I'm a 3L at the University of Florida. All of y'all kind of trotted on my question, but Damon, you kind of sparked the question, but I really want all of you all's insight. One of the statements that you said is garbage in, garbage out. Right. So at the University of Florida, we have basically an IP clinic, but they're teaching us Python and the coding language. And even to your point, Kurt, when you're teaching your associates how to employ or how you're going to be using it, my question to you is like, I think you mentioned in the bill there will be like an auditing portion. Like, how do you have someone to audit if they don't necessarily know like what retrieval augmentation, all of those things is, the nuances behind like Python and the coding language, because we're having to learn that at a surface level. And to your point, Professor Dawson, I'm the only black person, was 2 black men in the entire class. So who are the people in those rooms making those decisions? We're learning how to assign weights to different characters to produce these results. So my mindset always thinks there's implicit bias from data, from these over-surveilled communities, underrepresented communities. How do you even get to a point without having someone kind of like on that baseline level? I can really talk the talk of like, I know how this code works. I'm assigning these weights, because without it, once you couple it, because you start with the data, but I think you start before the data, you go with the algorithm and what are we even looking at to produce or analyze this data? So in a way, whoever wants to attack it, it's just like, how do you even compensate for some. It's like an attenuation of where you think it starts here, but it's beyond that. Because you go back to the data, it's like, how are we even getting the data? So you go to Palantir, these are the companies that are surveilling us. So sorry for the tangent, but holistically, I just don't understand, or that's what I'm trying to understand. Unless you have a multitude or army of people like, all right, we need you on the code, we need you on the data set, we need you on the the employment of it all. It's kind of where my mind is at, because when I'm in the clinic, I'm like, there's no way, it's 15 of us in there and it's one of me. And I'm like, I'm trying to speak for a plethora of not just, black and brown people, but all, misrepresented. So that's kind of where I was at. But your bill is like, when you have an audit, like, do you have a subject matter expert? And I know
So let me, this is oversimplification. Do you eat beef?
Yeah.
Okay, all right. So do you know what's in the hamburger meat, in the ground meat? I mean, I'm not. You don't have to answer. It's a semi-rhetorical question. But the point is that we actually have either relative confidence or oblivious, right, to what's in that ground meat when you buy it in the store. But we understand that there's a set of safety standards, that there is an agency that does either routine or spot inspections of these facilities. And then sometimes they find things, and there's such a thing as an acceptable amount of rat hair parts per billion in food. We'll put that aside, right? Right. So nothing's gonna be perfect, I guess, right? But there's a system that allows us to get the beef we want and have a relative degree of confidence, except for safety recalls, and for industry to flourish, right? That's what we're talking about. So AI is a tool, it's a product. Like what thing you learn in first year torch, product liability, strict liability. We are so far from that when it comes to AI. And I will say, the reason why it may feel so impossible is that you can't really do it from the outside looking in. It has to be baked in to the design process, who's in the room, but also what rules are they playing by, and how do we, I think the rub is like, how do we know they're playing by the rules? That requires transparency. So in the litigation we have against Meta, we're trying to get all in that business about what's the algorithm, how are you doing the things that we've alleged that you do. So how that discovery process plays out or not is going to be really interesting, Roy. I wish I could consult Roy on this more, but as a former employee. But anyway, I want to acknowledge too, for more detailed answer, because I have to go after this panel. I have two colleagues in the room. Alex Alt, if you can raise your hand, is one of the architects of the model bill called the Online Civil Rights Act that led to the AI Civil Rights Act. He's on our team. And Shatora Roberson, sitting right next to him, is on our staff. We built the Digital Justice Initiative of multiple litigators and multiple policy people by bringing in people like them. Alex is a Hill veteran. Shatora came from Tesla. So we're serious about doing what we can from the outside, but we need the audit requirement to be standardized, and a lot of the work has to happen inside with transparency and reporting.
Can I make 3 quick points? Just they're all different. Law firms in particular, one of the challenges that we are seeing is that the historic model for law firms is the old people train the new people. The old people don't know any of this stuff, and so we're having to figure out how we're going to train them, and that's going to be a real challenge. 2, I think that one of the points I would take away from your question is that there's going to be, and this maybe goes back to what Professor Dawson was saying, there's going to be a lot of jobs that are not the kind of jobs you're necessarily thinking about. I mean, it's not necessarily going to be a law firm associate, but somebody who can understand computer language and the audit, I mean, all of that stuff is going to create a new category of jobs where being a lawyer, having a law background is going to be useful, but it may not be a job that's, so that's just something to think about. Third point I want to make quickly about the law, going back to what I started with. One of the things that we're seeing in the law today is, like, I can look at AI models and know that they are the garbage in, garbage out. And if I know what I'm doing, I know how I want to fix that, right? I want to bring in data from more diverse audiences, things like that. But we're seeing a tension with the privacy laws that's making it harder to find those people and harder to find that data and harder to bring that in. And so we're seeing a tension between different kinds of laws with maybe similar goals, but it's just where those laws are in real tension, and it's going to make that hard to do. So I think there's not enough thinking about how these pieces are all going to fit together in the legal structure.
Sure. Did you have a follow-on to that, or?
No, I just had a question. I'm so sorry.
I think I had you next, and then we can go to you. Sorry, go ahead. And please, yes, say where you're from as
Good
you
morning,
ask your
everyone.
question.
My name is John Fadubabe, and I serve as a legislative analyst for Assemblyman Clyde Vanell of the New York State Legislature. And I had two questions. My first question, I believe, somewhat was touched on. My question relates to how artificial intelligence is revolutionizing the judicial system and the kind of responsibility that attorneys now have when it comes to dependence on these systems. I think in our conversations that we are having, especially when we talk about AI literacy with in the legal space, while I think we strongly believe that's important that we're staying literate on this technology, there also is a risk when it comes to over dependence, and when it has real life implications, real life impacts. How are we ensuring that the judicial system is staying up to date when it comes to making decisions that are going to eventually end up affecting someone in real life? And my second question is open up to everyone. And when it comes to creating that federal framework, I know states like New York are very progressive in the technology space. Governor Hochul has released multiple agendas to oversee digital innovation, and New York obviously has done a lot in this space with my assemblyman working on several bills that would oversee financial technology, healthcare, and I think my question, I guess, the second point is how can states support the federal government in creating policy that would approach this issue multilaterally, since there's so many angles to approach it when it comes to privacy and it comes to literacy and knowledge. I think the question about how you create that legal framework, how can states better support the federal government in doing so when we have bills in New York State like the AI Bill of Rights, which you mentioned, there's bills that have been proposed similar to that. How can the state government support those initiatives?
Yeah, you
Yeah,
can.
I'll start with the judicial use of AI. I will say I've been fairly impressed with how judges are thinking about the impact of AI on what they do as far as judging and leveraging large language models. And I'm sure everyone has heard about the lawyers who have used these tools, and you've got the fake citations. There's this website. I mean, this is happening every week, right? There's a lawyer that's doing this. We've had a couple of federal judges and some state judges who have issued orders that have had hallucinated fake cases. And so the judiciary is doing a much better job of kind of getting on board and learning about the technology. I would say the bar, less so, and in part because you have certain states, certain bar associations that are progressive, but others that are not. You also have lawyers who, because they don't use the technology, the first time they do, they think it's magic. And because the output is so credible, it's written like a lawyer because it's trained to write output like a lawyer, you assume that everything is correct. So we really do need to make sure that we increase our level of AI literacy. I think the judiciary is doing a good job, bar associations are doing better, but legal educators, law schools, we really do need to be at the cutting edge to make sure that our students, when they become lawyers, are already familiar with the technology.
And let me take on the second part of that. You know what you need to do is you need to get together with all the states that want to do any kind of regulation on AI. And you need to get together with Damon and his team, and you all together need to come up with what it should look like and regulate it across all of those states. Each state doing its own thing is crazy, and it's not going to work. Come together, all the states that care about these issues, come together, support what Colorado is doing. Colorado has a law passed that actually protects civil rights. They're afraid to actually put it in force because the tech companies are coming after all of them. But if all of you come together, you call California and you call New Jersey and you call Pennsylvania, and you come together and come up with what the law should look like, you could actually create something that is meaningful and that the tech companies cannot then tear you all down for doing.
That's a word. I would only add, let's also, I'm not aware of such laws in Delaware, but that's a lovely state. and those of you who have taken corporations know why, because that's where a lot of corporations are incorporated and their agents are. So I love what Roy had to say about that. That's it's next level. It's also very simple and achievable. At least having those conversations. I will also say I want all of the states you're talking about to endorse the AI Civil Rights Act as well, and also help us figure out how ways that it may be improved or modified, because there's going to be time, because we're going to have to come back next Congress on this as well, so we can have some feedback loop between what they're seeing and what we're doing.
And just to riff on this for a minute and tie it together, the organizing that Roy is talking about that you are uniquely positioned to do as you are lawyers going out into the world is also the organizing that you should be doing in law school, to Professor Dawson's point about what you guys need right now. And even to Kirk's point about the older lawyers not necessarily being there, that is true, frankly, in many of our law schools. Folks aren't ready. You guys need to demand what you need to be prepared for this moment. We've got time for one more question. Elise, thank you.
I'm Elise Daniels. I'm a 3L here at Russell. Thank you for joining us today. So we spoke about how, well, you all spoke about how AI is evolving very quickly and everything related. I remember just last year, Professor Dawson visited AI and Civil Rights, our class, my 2L year, and she introduced us to the concept of agentic AI and how that was the next big push. And I've been hearing more about agentic AI. And just recently, literally this past weekend, I've been introduced to quantum AI. And I'm still trying to wrap my head around what that means. I think it will have a big positive impact in the healthcare industry and maybe in the weapons of mass destruction or war industry, and less so on what we as regular consumers, how we may be using AI as far as with OpenAI or with Claude, in our everyday usage. I think quantum AI may look very differently. So I'm just wondering, it's a very big, open question. What are your thoughts on quantum AI, if you're familiar with it yet? How do you think it will impact how people use AI? How will it impact regulation to come? And just thoughts.
Let me take the last part about the regulations, which is I think that one of the challenges we're going to see, even if you were thinking carefully about regulating AI right now, I'm not sure what you're doing exactly to regulate that. It's the technology is moving so fast. There was an effort in Congress a couple of years ago to pass a national AI law. We don't have a national privacy law after 25 years of trying. They were looking at a national AI law. I expected that to be a disaster if it got passed, because they wouldn't have had any particular good idea about what they were doing yet. And so I think that the challenge is going to be to try to figure out some generalized principles that cross all of these different technological models. You're going to need regulation that is not dependent on a specific kind of technology, because if you try to target a specific technology, you're going to miss other things, and you're going to have to keep up. So you've got to get these general principles across all these models, and I just don't think we have those yet.
Yeah, and I'll just add that, and wonderful to see you again, that, ChatGPT was released in November of 2022. It feels like it was much, like a decade or two ago. It was just 2022. And we now have OpenClaw, right, which are these individual agentic AI systems that people are running in their homes on their Mac Mini. And we could not have predicted LLMs or these agents 5 years ago. So what quantum computing really kind of tells us is that things are continuing to move in directions and ways that we can't predict. And so to go back to Kirk's point about regulating based on principles, about best practices, Damon mentioned that, we have these civil rights laws that we can apply to any type of technology. They don't slow down the innovation. And the second thing is, you said you already have a job, because if you ever, are looking for something else, let me know, because the question that you ask demonstrates exactly where we need all of our law students to be, thinking about the future, what's around the corner. The value that you're going to bring to your organization just because you are thinking in that way is just exceptional. So thank you for the great question.
Thanks, Professor Dawson. Yes, so join me in thanking the panel, and thank all of you for your great questions.
While our next panel gets sets up for those who are online, feel free to take a quick break, but come back. And those who are in the room, we have refreshments and breakfast that way. We're going to give them about 5 minutes to set up, and we will come back.